elaborately defined in the code, but I must say this is the second chance which is available to a corporate debtor to get revived or to fulfill the objective of the code. Either it may be a going concern or it can be a gone concern otherwise. As far as this intent is concerned or the purpose of the code is concerned, it can be outlined in the very purpose or the objective of the code. That it's all about revival or to bringing the corporate debtor back on its feet, maybe through some kind of arrangement through which a resolution plan, if it is proposed, if it is approved, and if it is finalized by the adjudicating authority, and if not confirmed, then also even after the liquidation order is being passed, the possibilities are there. The liquidator will strive in case if the corporate debtor can still be revived through the way of scheme of compromise and arrangement, and selling the corporate debtor as a going concern before selling it in a piecemeal way, or on, you can say, on a slum sale or on any other basis through which a disposal of the asset of the corporate debtor may be possible, but the first attempts will be made to sell out the corporate debtor or the business of the corporate debtor as a going concern, so that the locus or the status of the corporate entity shall remain live. The objective of the code, even though if it is failed in the CIRP, though no plan was approved by the COC or though no plan was confirmed by the adjudicating authority, but by the way of selling off a company or the corporate debtor by the means of going concern or by the means of sell as a going concern, the objective shall remain upheld. As far as this selling a corporate debtor as a going concern is concerned, now I just wanted to have certain things which are not so much clear in the code itself or regulation itself. Even though regulation 32A, which is talking about selling a corporate debtor in a going concern, based on whatever was the recommendation of the committee of creditor when the company was on the verge of that liquidation and when the plan was not approved, and when it was decided by the COC that this can be opted by the liquidator, that the efforts can be made to sell out the company as a going concern. But now the question, if I'm a purchaser, if I'm buying a company through auction process, I'm a successful bidder, acquired the company on a going concern basis, I've acquired the company in the procedure of sell as a going concern basis. Now the locus of me vis-a-vis the locus of a successful resolution applicant. Secondly, the relief and concessions which are being paid in the resolution plan, vis-a-vis if I'm acquiring a company, a corporate debtor in a going concern basis. Now, as far as purchasing an entity through going concern means, absolutely this is going to be the first thing which will be opted by the liquidator in case if there was a strong recommendation on the part of the committee of creditors. Corporate debtor was ordered for liquidation, and it was the liquidator who have decided identify the assets to be sold out, the liability to be sold out in a going concern basis, and post that when the efforts are made to sell out the company as a going concern basis, it is the status of the company will be handed over to the person who is willing to acquire the entity on as is where is basis. Before we proceed with this, I would like to reconcile the provisions of the code, the insolvency and bankruptcy code, which is aiming that company should remain live, company should remain operative, or company should continue to act as a going concern, even though there are very less possibilities in case if the entities are operative, there is always a possibility wherein IRP or the RP may strive to keep the company running or to keep the company operative. Otherwise, also, the provisions of the code is aiming to keep the company alive or to keep the company operative. But always there is a question pertaining to the resources. In absence of the sufficient resources or in absence of the requisite resources through which you can able to keep the company as a going concern, it is hardly it is hardly remain operative during the stage of CIRP or during the stage of liquidation. So, as far as the practical difficulties are concerned, you as an IRP or RP or liquidator can understand what are the teething problem, irrespective of whatever is stated in the code prints of the code. But otherwise, to have an entity and to keep the entity running, or to manage the entity and a going concern, is a very, very difficult task which IRP or RP generally can able to handle, because of the only concern pertaining to either the non cooperation on the one side, lack of resources on the other side, multiple round of litigation on the other side, and the timeliness, which is one of the you can say one of the very prominent feature of the code, is on the other side. So before we proceed with that, I will be appreciating your views, that which are the matter of concerns right now amongst the IRP or RP or the liquidator, which are being faced on a regular basis when they are trying to make an attempt to sell the company as a going concern. Which are those areas we are supposed to deliberate upon or to discuss upon? That is first thing which I would like to have from you, so that at least rather than emphasizing on a point which is not so relevant, we should touch upon that aspect, we can deliberate upon those aspects, and we should reach out to certain conclusion which can be in the form of a recommendation, or which can be in form of discussing the practical difficulties in the process. I would like to appreciate, or I'll invite your views or suggestions, or the matter of concern which we need to take care of, or the aspect wherein the practical difficulties are being faced by the liquidator or the RP during such case wherein they are making an attempt to sell the company as a going concern, and the issues are coming in between. Otherwise, as far as the agendas of discussion is concerned, I would like to reach out to this topic, or I would like to touch upon this topic from the very beginning of the code, that where it is provided or prescribed in the code, certain provisions which is directly talking about, say, for example, moratorium, but there is no moratorium as far as the supply of essential services is concerned. Now, again, the intent is very clear, that to keep the companies veins working, to keep the company heart working, to keep the company operative, so that it can able to generate, or it can able to get the value as a going concern, which can be more than what in case if the company will be liquidated. So I'll be touching upon those aspects which is well within the code. Thereafter, would like to reach out to that CIRP regulation, that is IBBI insolvency resolution process for corporate persons regulations. And thereafter, I will be touching upon the aspect of regulation 32 and regulation 32A of the liquidation regulation. But before I touch upon those aspects, I'll appreciate in case if you have something to highlight on the subject part, or something wherein you want that areas to be stressed upon, to deliberate upon, so that I can first point out those aspects of discussion without referring to the areas which are otherwise known to the professionals.
As far as the sale as a going concern is
Yes, sir.
concerned, as how many successful cases has there been? Because whatever I have seen, to my mind, it's a fiction of IBBI's imagination rather than any sound basis in either company law or IBC. The IBC, the Act doesn't talk about this at all. And how can a company be liquidated and not liquidated? The liquidation logically should culminate in a dissolution of the company. Here, what you are trying to do is basically give it some kind of a clothing and say that it's a sale as a going concern. And you also say in the regulation that some assets and liabilities have to be bunched in. What assets, what liability? All the liabilities in a liquidation are supposed to be settled as per the waterfall mechanism under Section 53. Assets, one can understand. Business, one can understand. Now, when you sell that, then the so-called the buyer would also want to have the same reliefs as
A successful
one
resolution
RA
relief.
would have, right? The yeah, RA, SRA would have. Now, again, uh, if that was to happen, then why it did not happen during
Mhm.
CIRP, right? So, if there is I read one recent judgment couple of days back. I think it is I am not remembering the name. Pardon me, but it simply said that the same set of reliefs that are to be given in a resolution plan cannot be given verbatim in sale as a going concern, because the buyer is buying it as a as is, where is, what is, whatever there is basis. So this was a very recent judgment. So I don't know. I have never done a sale as a going concern, uh, because of late people are buying shell companies also. Uh, so somehow I don't agree with that. So I don't put it up anyway.
I'm backing your concern in this case, sir. But the point is now the dominance or the influence or the control which is there in the resolution plan as far as the COC is concerned. Now, that kind of control or that dominance or that driving force with the liquidator is not there. As far as the influence of the COC is concerned, that is one of the aspect that many of the things for getting the resolution plan approved or to get that resolution plan approved and get it through the adjudicating authority, the role of COC is dominant, be it commercial wisdom or otherwise. As far as the selling a company as a going concern is concerned, the moment the liquidation order is passed, it is the liquidator's prerogative to decide the fate of the corporate debtor during initial days, that can this be disposed of if no plan is approved. And this is what I told, either it is sell as a going concern, either it can be, this is a second chance, this is the second chance of revival, which is the best possible chance after approval of the resolution plan. If not approved, either it is going concern or otherwise it is a gone concern. So I believe, as far as the liquidator's dominance is concerned, with regards to taking up this reason that whether to sell the company as a going concern or not, the COC's intervention, which otherwise available in the company's resolution plan, which is passing through a COC mechanism and then to the adjudicating authority, that kind of independentness which is available with the liquidator can make this thing simpler, especially for those company wherein the resolution plan were available but not pass through the necessary test of the COC and the adjudicating authority. That is what my understanding says about this regulation 32.
I think IBBI is in its upcoming draft or something is planning to discard this whole concept as a whole, and is planning to say that if you even after liquidation, if you feel that there is a possibility of revival, then you can halt the liquidation and go back into CIRP. This is
And that
something
should be
was.
there, that should be
Hmm,
there, and that is going to serve the purpose. One more
hmm,
change which I have seen in regulation 36, somewhere 36b, wherein now asset wise EOI is permitted by the code. So when I will be
right.
inviting resolution plan on per asset basis, probably I'm not going to get a resolution plan for the company as a whole, and probably the concept of sell as a going concern may not last as far as the concept, because when the assets of the company will be disposed of in a manner of resolution plan, probably the investor will be more keen to take up the lucrative side of the company rather than company as a whole. So I believe that as
True.
far as the going concern concept is concerned, that is going to face a direct impact on the basis of that whatever amendment which has recently brought in the May 2025 pertaining to inviting EOI on a very first instance for all the asset or for separate asset of the corporate debtor, of course with the approval of the COC.
So here again, the concern is, let's say, I suppose this was done to facilitate real estate kind of cases where there are several projects, right? Now, the question arises, how do you separate the liabilities?
Correct.
If the lending has happened a- at the builder as a whole, as a company, as a holding company level, uh, then supposing a project A goes into, uh, you invite a resolution plan for project A. How much of the liability, how much of the liability or how much of the claim will you assign to project A?
Particular project.
A particular project. Householders' claim may be different because they are interested in a particular project itself, right? But financial institutions may be lending to, let's say, if it is DLF group, they may be lending to the holding company some huge amount, you know, and they will then allocate according to certain project. But the financial creditors, the institutional financial creditors, it will be very complex. So if some 1,000 crores is lent to a group, and couple of you're inviting EOI, some of them have not even taken off, so you can't, invite a EOI. Some places there are land disputes with the landowning authorities. Question arises, how much of the uh, liability
To be appropriated
will
per
you
asset.
come off
Correct.
to a, and what basis? Is there any guidelines as far as the CA Institute is concerned who has come out with something like this? So this is again, in my view, a figment of imagination. So what is being sought to be done by subordinate legislation, by way of regulation, is basically extending the act. You know, you're
Absolutely.
trying to amend the act by way of regulations, which somewhere along the navigation get stuck down. So we are again going into a very uncharted territory.
Correct.
I don't see this taking off just like your sale as a going concern. Of late, I've seen a lot of demand for sale as a going concern, but that's basically for
Correct.
shell companies.
Correct.
So I get, you know, so I don't know what's going to happen to this, but fine. My basic point is that you can't change the act by way of a subordinate legislation. You need the parliament to change the act. And not only IBC, also Companies Act.
Correct.
Otherwise, how will you do it?
Yeah. So I agree with Mr. Santanu. I think it is a complex. So first, a few observation. One is now since asset-wise sale has been allowed, there is no need for sale of the corporate debtor as a going concern under liquidation process. Uh, so COC before it is recommended for liquidation, they have to decide whether it is to be sold as a going concern or not. But still, I have
Correct.
seen that even though COC has decided not to proceed uh, for sale as going concern, still NCLT order stipulates sale as a going concern. Uh,
Hmm.
Maybe because it is a sort of, some standard orders are issued, so then it becomes COC is in a bind, because it's a part of the NCLT order. They have to continue, and SCC cannot. Generally, they don't go against NCLT order. So a lot of delays happen on account of that. Because the liquidator and SCC both they try to find a solution through going concern also. So I think so once this asset sale is, so I had also 2 3 year back suggested to everywhere that then this liquidation as a going concern that should not be there. Uh,
Correct.
other other aspect is Shantanu, which I've read is very much practical. How to when you go for asset sale, how to distribute the liabilities, how to assign the liabilities, how to assign the disputes on one particular assets. I think that becomes very complex. I think so when RP and COC have to be very much proactively see that these are segregated appropriately so that RAs for those assets, uh, can have clarity on that. But if we want only SRA to define those assign those liability to those assets, then I
Absolutely.
feel it will not be resolutions won't be achieved.
And this is what being done in absence of any clear terms with regards to the modus of segregating the liability, or in absence of any specific regulation to this regard. What is being done is this only. It is the SRA which is proposing that this is going to be the mode through which I'm going to acquire. This is the manner in which the liability will be taken care of, or this is the way I want corporate debtor. Now, another concern with regards to this is, in case of resolution plan, there is always a condition that you need to keep the company running or operative. Here, there is no such kind of condition. So, suppose if I'm acquiring a corporate debtor as a going concern basis, as is various basis, and what I'm doing is I'm disposing of the asset in my own price, because I know I can able to fetch the value which is much beyond the value which is right now appropriated for a particular asset in the CIRP or liquidation procedure. So this is again not meeting the ultimate purpose of the code. So if I am taking over a corporate debtor as a going concern, and after acquiring the corporate debtor as a going concern, leave the liability part. But what I'm doing is again the same thing, which otherwise may also be possible in that liquidation process. So I, in a piecemeal manner, is disposing of the plant, machinery, land, building, and I'm gaining the value which is much more than the value which probably was assigned during the course of liquidation procedure by a registered valuer. So that is another part wherein there is no stipulation that whether I need to keep the company running operative or I can dispose of the asset in a manner which is most desirable to me.
See, let me give you one example. The company's PF and gratuity liability that will be for the company as a whole.
Correct.
Uh, and now, as part of a resolution plan, all PF and gratuity liability has to be provided in the plan. But it becomes very difficult to assign these liability to the asset wise. So it becomes uh, literally a nightmare for the lenders to see how to it uh,
Absolutely.
di- distributed.
Absolutely. And I have one more thought in this regard. Now, rather than having, because I've seen certain reliefs and concessions are being granted, certain relief and concessions are being not being granted with this mentioning of the fact that you approach the authority and let the authority to take the final call. Now, authorities are not so again very much versed with what the code is all about, because in the code there is no provision which talks about gaining the benefit of relief or to have the benefit of, you can say, this kind of concessions. So I believe that there has to be a corresponding change in the law, in the corresponding law, be it income tax or be it companies act, so that there is no purpose what is to be granted, what is not to be granted, and there has to be a parameter, or there has to be a streamline in terms of that what is going to be, or up to what extent a relief can be sought, up to what extent a relief may be granted, and whether it is going to be granted by the specific registrar or the IT department, or whether it can be granted directly, just like you can say a blanket approval, or you can say this is what we generally place before the adjudicating authority for the approval, single window clearance. So I believe that as far as a relief and concession is concerned now, unlike what we used to study, as far as the resolution plans are concerned and seeking such relief and concession in the plan is concerned, now there is no such kind of stipulation which is available as far as the selling of a company as a going concern basis, but still the applications are being made, still such kind of relief and concessions are being granted fully or partially. So as far as whatever is being done, it is right now being a procedure which is being adopted by the benches, considering the practice being adopted by some other bench or by some other, you can say, adjudicating authority. So I must say that as far as the procedure is concerned, of course, there is a provision which talks about selling a company as a going concern. But in what sense, in what manner, and as you rightly said, appropriation of the liability part is concerned, there is no standard formula or there is no basis on which this is being evaluated.
Right. So it is basically, I think the RP and COC has to work out so that minimum, so these things are sorted out upfront with the SRAs, and then plans are submitted for approval. Otherwise, this become a messy affair.
I differ this views, because if this can be granted to the RP and COC to decide, then in that case, every practice will be a private practice. So in one of the case, this is being adopted. On the other case, this may not be adopted. And there will be this, this may probably give a rise to the another channel or another round of litigation. So unless it is prescribed within the cold prints of regulation or the law, I don't think so. It's a COC will be mature enough to decide that though the commercial wisdom or the head of the commercial wisdom is being exclusively mean to them, but if it
I'm
is
sorry.
they are
I'm sorry to say, but to say that COC not mature, but I think they have to become mature because entire commercial wisdom is given to them, and
absolutely on
NCLT can't look into the distribution part that is against COC domain. Everything, I think, if the lenders or the COC does not do its duty, then I don't think the NCLT or these regulatory agencies can do that. So finally,
again now the
the
concern
solution
is
has to be found at COC and at RA level at that point only, so that a complete plan can be submitted and which is then approved by the adjudicating authority. I mean, that is just a
I
point, but
understand.
it may
I
not be,
understand your
yeah,
concern.
in possible in all
Now,
cases.
again, what is lacking is, see, if I am acting as an IRP, RP, or a liquidator, I am bound by the code of conduct, or I'm being governed by, I'm being monitored by the insolvency professional agencies or the IBBI or even the adjudicating authority. Now, as far as the conduct of the COC is concerned, there is no dominance over the COC.
Absolutely. Absolutely.
There is no
Absolutely.
conduct defined for the COC. Not even adjudicating authorities are taking necessary actions against the misconduct of the COC member, and there is no other body looking after the same. As far as IBBI is concerned, there is no kind of, you can say, they are not even considered as a monitoring agency for the stakeholders or this committee, what we call the COC.
Yes, you are absolutely right. I think RP as a facilitator, he can only facilitate. That is
Absolutely.
what I'm saying. He can facilitate, but finally, it is the COC who has to understand if the plan is to succeed.
Correct, sir. Correct. Would like to appreciate in case if you have any views which may be conflicting in nature, but this is the ultimate objective of the sessions being planned. But I believe this is one of the, of course, the facilitator, or of course the key driver to this procedure is clueless in absence of such kind of regulations or the rules or there is a protocols. But otherwise, this is one of the second best alternative or the rescue or the second option, which is de facto like a resolution plan, which is mean for the investor to bid upon such kind of company for which the resolution plan was not considered or was not passed through. So, in case if there is no views other than what we discussed, I would like to go into the code prints again. I would like to go back to the code. I would like to see or touch upon all those area wherein the intent can be identified, the purpose or the objective can be identified. That this is the overall objective. If plan is received, it's good, which will define the ultimate fate of the company. By that plan, the company will remain its, or company will keep its identity intact, and since the company will remain its identity intact, the objective of the code is going to be achieved. But in absence of that, the ultimate point of discussion which is right now been assigned to me, then sale of going concern will be the another part to deliberate upon, because that is the only aspect then through which you can think upon not proceeding ahead with the liquidation procedure and just sell the company to the investor who is the ultimate person who is willing to bid for the asset and liability, or to acquire the asset and liability with all the, you can say, the status of the company as a whole, will get all the benefits, will be taking care of the liability, and yes, will be the ultimate person who is now further on will decide the fate or the fortune of the entity. I would like to share the code with you, and we will be dealing with the code. Another thing which we are going to deal upon is the regulation, and then last we are going to take upon the aspect of the liquidation regulation. As far as the code is concerned, and I'm briefly touching upon the subject, I'm briefly touching upon the aspect which I believe is, as far as the subject is concerned, or as far as the topic assigned to me is concerned, are relevant for us to see. And this is what the maximization of the value of the asset of the company is concerned. Of this, going by this, one of the purpose or the objective for which the code is introduced, or code is amended, or code is notified, I believe that sale of a going concern, or sale of the company, or selling a company as a going concern, this is the reason I believe that if not a resolution plan, then at least by the way of selling of that entity through going concern, you are trying to keep, or you are trying to maintain the valuation of the asset. Because if now that will be left alone, or if it will be left, or the liquidator is going to decide that let us liquidate the entity, then probably selling the asset on a piecemeal basis, on individual basis, I may not able to fetch the value which otherwise I can fetch, or I can realize the value for the entire asset if I am selling the entire asset with all the defined asset with liability. I may able to fetch the value, but this is what I must say. This is the COC who used to decide when we study that IBBI insolvency resolution process for corporate persons regulation 39C. They used to decide that whatever is the cost which is going to be incurred, whether any liquid asset is available to take care of that cost, what in case if the company will be sold as a going concern. And again, the question mark will survive, that if the company will be sold as a going concern, and that is what we have discussed, and how to assign the liability in that case. Again, there are so many lacunas which are having no the gray area, what we call, that if I'm acquiring a company as a going concern, whether I will be getting the same locus as a successful resolution applicant, what I can trade for in terms of relief concession, and what is going to be the manner in which I'm going to settle the liability, or I'm going to discharge my obligation. Again, there is no monitoring committee sort of, you can say, agency who is going to oversee that whatever is proposed is being implemented or not. But yes, this is one of the objective on basis of which sell as a going concern can be considered as a right move in case if the ultimate order of liquidation is being passed. But to avoid the company to being scattered by the way of selling or disposing of its asset in a piecemeal fashion, it's advisable that this entire company for which a person can bid and take over the asset alongside the liability. I would like to reach out to section 13, because that is the section from which the entire handling of the CIRP starts by the IRP. So I'll not much deliberate upon the subject, because that is not exactly the point for which I have been assigned with this responsibility. As far as 13 is concerned, that is just talking about a declaration of moratorium and a public announcement. And this is a moratorium which is a purposeful, so that a corporate debtor during the course of its revival, or a corporate debtor during the course of its rehabilitation, or a corporate debtor during the course of inviting a resolution plan, the person proposing a plan should not get the hurdles during the process, and the person who is facilitating this resolution, be it IRP, RP, that person should not get such hurdles which otherwise may be there before him in absence of moratorium. So it is after the admission of the application under 7, 9 or 10 declaration of moratorium for the purpose of 14 public announcement. Now very relevant, because now this is the public announcement through which a public at large or the stakeholder at large can come to this, you can say, can reach out to this information that this company is in distress, or the insolvency resolution process is commenced and I have to submit my claim. Because now that is another nature of litigation: submission of claim, admission of claim, part admission of the claim, rejection of the claim. Now there is another level of litigation wherein the fight is between RP on the one side and a private individual on the other side, and he is fighting for the sake of his own interest, which otherwise is impacting the company's process, resolution process. And ambiguity always stays in the mind of the one who is willing to acquire that company as a qua resolution applicant. So this moratorium, and when you see the provision of the moratorium, ultimate provision of the moratorium is there in the objective of the code. The objective is going to be defeated if the provision of the moratorium can be expelled out, or if this can be expelled out, or if this is going to be expelled out, the objective is going to be badly impacted. And here we see it's a supply of essential goods or services to the corporate debtor, as may be specified, shall not be terminated or suspended or interrupted during the moratorium period. And this is the ultimate purpose, that is to realize the maximum value which a corporate debtor can able to gain if the services shall remain continued. And this is what is also provided in subsection 2A of section 14, which talks about the IRP or the RP, as the case may be, consider the supply of goods or services critical to protect and preserve the value of the corporate debtor and manage the operation of the corporate debtor as a going concern. Then such supply of goods and services shall not be terminated, suspended, or interrupted during the period of moratorium. Of course, you need to pay the dues during that procedure. And since this, whatever may be the amount payable, that shall form a part of the CIRP cost, so there is all a good reason for the service provider as well to keep such kind of services, or this shall remain continue, because ultimately their interest is being protected by considering this cost as a part of the CIRP cost. The order of moratorium shall have effect from the date of the order till the completion of the CIRP. Now, as far as section 17 is concerned, now here you have all the power of the management. It's you who need to manage the affair of the CD, and all the power of the board of directors or the partner of the corporate debtor, as the case may be, shall stand suspended and exercised by the IRP. All the power of the board of directors. And when I say power of the board of director, here I must say including the power of the shareholder, unless it is not conflicting with the power which are otherwise available with the COC under section 28. That means since the company is in CIRP, the equity shareholder has lost the locus. And when you see the Companies Act, the powers are segregated. Either it can be with the board or either it can be with the shareholder. Now, I must say, when the power of the board is being assigned to you, you are the one who is right now taking all or many of the decisions which otherwise can be taken only with the approval of the shareholders. Of course, if it is not a power falling within the ambit of the COC, then it's a you who need to decide majority of the things. As far as 18 is concerned, now 18 is again very important, and this 18 is indication, or it is an indicator of the fact that your intent is, or your objective is not inviting a resolution plan first. Your objective is, first of all, to gather the maximum information based on which your plan may not be proposed, or plan for the company may not be proposed. So as far as this 18 is concerned, this 18 is having a larger impact as far as the preparation of the IM is concerned. And IM is going to be the fundamental document which is going to define the fate of the resolution process in terms of proposing a resolution plan. Its IRP shall perform the following duties. Unfortunately, IRP gets very limited time. Collecting information relating to assets, finance, operations of the corporate debtor for determining the financial position of the corporate debtor, including information relating to the business operations of 2 years, financial and operational payment 2 years, list of assets and liability as on initiation date, other matters may be specified. But I believe this 18 is very relevant. 18 is going to be a fundamental provision on basis of which, or based on which, you can gather all the information which during the course of procedure many of the IRP or RP get to know that this is one of the asset or this is one of the litigation. So it is you who need to gather all the information, and I must say that the this is a basic backbone of the procedure. Monitor the asset of the corporate debtor and manage its operations until a RP is appointed by the committee of creditors. Taking over the custody of the asset, and unfortunately I've seen in many of the cases, in spite of the settled law, RP or the IRP failed to take out the custody, and we have seen many of the properties are still being visited by, still are being under the control and dominance of the erstwhile management. Taking control and custody of the asset over which the CD has ownership right, as recorded in the balance sheet of the CD, information utility or the depository of the securities. Personnel to extend the cooperation to an IRP. Now that depend upon who, it also makes a larger impact, because I've seen such applications are not being disposed of till the expiry of that statutory timeliness of 180 days or 270 days or 330 days, and these applications are still pending in the liquidation. So always question goes to IRP and RP that it raises a basic question about its caliber, that in the CIRP procedure you fail to get the necessary assistance, and in spite of that you have moved an application at that belated stage when a time comes when the liquidation order is going to be passed. This is very relevant as far as the objective of the code is concerned, and there is 20 which talks about management of the operations of the corporate debtor as a going concern. But hardly we have seen a company in CIRP running. Hardly we have seen a company in CIRP getting necessary assistance from its management. Hardly we have seen a company in CIRP is getting flawless services from its worker or the laborers or the employees. Hardly we have seen that in spite of keeping the company as a going concern, even the resources are supporting the IRP and RP to keep the company as a going concern. Hardly we have seen this. Of course, it is this code print which can states that the management of the operations of the corporate debtor is a going concern, but basically there is no going concern. Once CIRP commence, everything comes to a standstill condition. And I'm not talking about those big entities. And even though we have seen the big entities like Jet Airways, ultimately they have faced what ultimately the end of the procedure is all about. The IRP shall make every endeavor to protect and preserve the value of the property of the corporate debtor, manage the operation of the corporate debtor as a going concern. This is something which is very, very difficult for IRP or RP to manage the operations of the company as a going concern. IRP shall have the authority to appoint accountant, legal, other professional admin. Again, the cost. Enter into a contract on behalf of corporate debtor to amend, modify the contract or transactions. Raising interim finance provided that. Now one more amendment I've seen in 2025 May, 26th May 2025 amendment I've seen, wherein now with the permission of the COC you can also invite interim finance provider to attend the meeting, but unfortunately they don't have any say in that. So this is again going to raise a concern pertaining to the litigation in the process, because if I'm the interim finance provider with the permission, so it is the COC who is going to decide whether the IRP in that meeting will be allowed to participate or not participate. That means just as observer, not even as a a person who can recommend something or a person who can propose something just as an observer. Now he will be allowed to attend the meeting if the COC desires so, but having no say or no role in participation. As far as 25 is concerned, that is having some kind of relevance to the subject which we are dealing into. It shall be the duty of the RP to preserve and protect the assets of the corporate debtor, including the continued business operations of the corporate debtor. Now, my question before I proceed further, before I should proceed further, I'm just stopping this sharing part, and I just wanted to have, because I have many participants today who are eminent as far as this procedure is concerned, experienced in terms of this procedure is concerned, and they must have faced this issue. How easy or how difficult it is when a company of which you are an IRP or RP or a liquidator, and still you have seen that there are the chances to keep the company live, to keep company operative, to keep the company in motion, to keep the company running, and you have successfully, or you have got all the blessings in terms of assistance from all the erstwhile management or the support staff in terms of the employee or the labor or the workers, and you have managed to manage the show running, and that company has procured or realizable value which is otherwise was in the stage of getting liquidated. So I just wanted to check with you that is it practically possible that if company has faced a CIRP order and still the company is operating and the company is running, the unit is fully functioning, and you are getting assistance from all the corner as well as resources to keep the unit running. It's just a view which I wanted to have from you. Because we are talking about selling a company as a going concern at the stage wherein there is a going concern is just a theoretical part which is left out. I'm talking about the procedure wherein the CRP is just commenced, or a new phase IRP is just been replaced. It's 30-40 days old, and procedure is right now in its initial stage, and the company is being managed running. Company is still being managed operative, a going concern. I just wanted to check the practical aspect of this theory. I'll be happy to have your view, sir, your experience, sir. How practical this is. Because if it is practical, then the concept of selling an entity as a going concern should come first before inviting a resolution plan for a company. Then it should come much prior to CIRP commencement. Because I believe if entity is actually running as a going concern, operating as a going concern, then in that case, why to invite plan for such entity and why not to sell company as a going concern? And that should be the first bullet I should hit rather than inviting a plan for company and they decide the fate.
But then that will again require some change in the law,
Absolutely,
right?
sir. But this is what the striking point is, sir. My question is, when you manage an
So,
entity,
so that way, if the lenders were to convert their debt into equity, there was some provisions, if I remember correctly before, that the lenders could actually take over the management of the company by converting their debt into equity, and they could palm off the equity to someone else. If you have a debt and you take over the management by way of.
I'm getting it, sir. You are talking about restructuring the debt and just giving them the ownership. But again, my question is a company who is in distress, whether equity will realize its value or whether the lender will be keen so in getting the equity of the entity which is right now in a very financial trouble.
No, I'm saying that's the way. That's one way of selling it.
But
That.
this
Hmm,
my initial concern is, sir, during the
hmm.
course when you handle a company as an IRP or RP, have you seen the company faced a CIRP order but still running an operative and maintaining its status as an operative entity? Can
See,
hmm,
see, there are some companies who can be, you know, they have already defaulted. They have come to a stage where some operations, maybe a little bit of a operations is running around. You know,
correct,
several units are closed, but one unit is running, or the management has kept one unit running somehow. In such a case, uh, yeah, you can try and keep the unit running to its extent, but then what happens is the moment it goes into CIRP, what I have seen is the managements have somehow managed to keep the other compliances away. Let's say the factory inspector or the safety guy, th- they have been managed, right? They have been
correct,
managed. The moment RP steps into that uh, role, he becomes the occupier. And if the management does not want, then the same compliances which they have not done so far, uh, these guys will all of a sudden wake up and say, boss, this is not compliant, this is not compliant, this is not compliant. In a way, I think there was one case somewhere, again, I think it's in Hyderabad or some this thing, where the RP was declared as the occupier of the factory. Okay. And he was, he could be prosecuted for uh, some kind of, what you call say, if there was some lapse in the uh, fire safety uh, of that factory and things like that. And those can even attract criminal penalties. Now, when I read that order, I pretty much thought, boss, this is nothing but the erstwhile management trying to put the pressure on the IRP by activating all these things which were, it could not be a thing that the RP did by non-compliance. This non-compliance would be continuing. So it's difficult actually.
very
Some
difficult.
way if it's some way if the uh, you know because it's basically the RP who gets left holding the baby. So very difficult. The COC in most cases will not be able to take any decision like that. Yeah, whatever is running, you can keep it running to some extent. But there was one company where I was the IRP. The moment I got appointed the IRP, the electricity guys who were otherwise supplying electricity to the company, all of a sudden woke up and wanted to cut the electricity. You know, so I said, okay. They wanted a guarantee from the IRP that their current dues will be paid. So I said, how do I give you that guarantee when the company is not
Functioning,
operating? Not operating to that extent. So these challenges are there.
absolutely.
It's the system gangs up, and most probably it's the promoter who is behind all of this. This has
That's
been
what I'm
my
telling you.
first-hand experience.
Correct.
This has been my first-hand experience in some cases that I've handled.
Thank you, sir.
So, sir,
Because
they need to actually amend the act. They have not amended the act for a long time.
hmm,
They have done many things through just regulation, regulation, regulation. It's
hmm,
only creating a this thing. These things have to be very clearly defined. Is the RP the occupier? If the RP is the occupier of that factory premises and is liable for all this thing, if the uh, in the past, if these were not compliant, is he bound to immediately set it right? Because he would not have the money also.
correct.
And can he be prosecuted? So there is no safeguard for the RP also. Why should I keep it running as a going concern if I see a non-compliance? I
Absolutely.
would I would rather shut it down.
So that was my question, sir. As far as this code prints in the code is concerned, keeping the company as a going concern or managing the company as a going concern, this is mere theory. Because what I believe, once the company has faced an order of CRP, I can see the Gensol situation. On the one side, the lenders are before him. On the other side, the Union of India is before him. And ultimately, the step which is initiated by the Union of India before the lender has approached the NCLT Ahmedabad bench, ultimately from the day they have got the interim order on 28th May, all the operations have been shut. The fleets are not working. The employees who were the cab drivers have been unemployed. So I believe, as far as the announcement is sufficient for a company to get its operation closed, how can the entity remain as a going concern when this announcement is that tedious, which always gives a kind of fear in the mind of every stakeholder that there is no need to contribute to the company when I'm not going to get anything out of this company?
Right. You're right. And the whole onus is put on the
Single
RP,
person. Yes, sir.
on a single person, because there was a forum where I had also there were some bankers, very senior bankers, and the IBBI chairman was there. So I just asked a simple question: if the COC is in control, then why is the COC not responsible?
Correct.
In terms of, if you are suspending the board of directors and COC is taking the day-to-day decision, then the COC should have the same liability and
Absolutely.
responsibility as a board of directors.
Because ultimately they are the ultimate beneficiaries to this procedure.
Precisely. So if creditor is in control, why is the creditor not responsible?
Absolutely.
Nobody had an answer. Probably that was the uncomfortable question, so nobody had an answer.
And that was my concern initially as well. There is no monitoring agency to COC. There is no disciplinary actions being taken by the COC. So ultimately, when the COC, in spite of wearing the hat of taking the final call in terms of the commercial wisdom, but if this wisdom is, there is nobody to judge that commercial wisdom over and above what COC is judging, then ultimately they are going to define, or they are going to decide the road in which the CIRP should move or the liquidation should be opted. I go by this, sir.
Yeah, I agree with your view, sir. Even I've seen this up in cases after cases. And also, there is no logic of only keeping the financial creditors in the COC, honestly, because they will only look after their own interest.
Correct.
So all this, stuff that reviving the company and things like that, that doesn't happen. If you're only having a banker as a COC member, he's only looking after his recovery.
Correct.
He's certainly not looking after whether the company will come back, this thing, come back on its feet and things like that. How many cases, if in a resolution plan, somebody says that, okay, I offer you a part of your debt by way of equity, that should have been possible. Okay, here I am restructuring the company, this much I give you upfront, rest I give you equity as I uh, turn it around, and you also benefit.
Correct.
No banker will take it. Not even to a restructured this thing. Supposing a new RA is coming in and he says, "Ki part of my this thing, I will offer you some equity in the enterprise."
Hmm.
None of the banks will take it.
Correct.
Why not? If revival is the
The key
objective,
objective which you are. Correct.
So then if I'm reviving it, if you're giving me the company, why don't you want to be part of the success of the company also?
Absolutely.
And the same lenders will again not lend to the that CD also. You will not get this thing. So
Correct.
coming to this interim finance part which you talked about, the new regulation, the interim finance person can come and sit in the COC and do what?
Correct.
And do what?
So
They
basically, it's
don't
a
have a
COC
say.
member. It's a COC member who should be the first provider to that interim finance. That should be the
Absolutely.
first.
Absolutely. But they don't do
Hello,
that. Haji, please.
hello. This is Yogesh Sharma, IP. I was listening to this interesting conversation on CSC and commercial wisdom between Vinit and Shantanu Dada. I mean, let's focus the reality. Who are the COC members? They are the. Do they have the decision making powers? Are they really interested? In doing some, or do they have those powers, even appropriate powers to decide on the table? When the COC happens, most of them comes for the sake of attendance and making sure that if they are being represented. It only leaves up to the commercial wisdom of RP, because RP is the only person who have some interest, who have inherent interest to drive the process further, and then make it sure it reaches somewhere, because he's been
Correct.
directed by the authority to do so.
Correct.
That will COC members have no such interest. Senior decision makers of the banks never joins the CRC. They send the junior managers or middle level managers to participate. And so one should not expect too much commercial wisdom coming from the COC members as such. It will boil down to, and it actually gets into the RP's wisdom only, which drives the COC. And so therefore, I think it's the RP who gets stuck, who faces the music, always. This is what happens. That's unfortunate. That's the reality. And the second part, one point was raised here was that whether RP is the occupier of the unit or not. But let's look at theoretically. Let's look at theory. When RP de facto assumes the power of the board, and somewhere steps into the shoe of the managing director of the business. So by stepping into the shoes of the MD and by having the de facto control, what
Okay.
theoretically, theoretically, he assumes that role and their powers. So if there's a manufacturing enterprise, the occupier would mean the person who have the de facto controls. So in theory, yes, he gets into that shoe. But in reality, is that should he and is he or should he be responsible for the previous deeds and previous acts? So those are the open questions, which has been raised validly by the
So that's
by
what I was
Santanu sir.
saying. That's what I
Yeah,
was saying. So somewhere in the regulation
yeah,
or the act, it should come that
yeah,
I am responsible from the day I take over. Now,
yeah.
secondly, let's say you are the RP of a particular company and the company is having certain defaults,
Yeah,
running defaults in terms
yeah,
of certain compliance, industrial compliance
yeah,
and stuff like that. Now,
yeah.
if you are asked to set it right from day one, how
Yeah.
can you? Because you don't have the financial authority.
No, no,
Fine,
I'm
fine.
with you. I'm with you on that. I'm with you on that. For the previous acts and deeds, like a director cannot be held responsible. New director cannot be held responsible for the previous acts and previous deeds of the management or
No,
decision
so I
taken in
I
the
I
past.
I, I I am trying to
Yes.
IRP today. Okay, and
Hmm.
fire safety or whatever industrial safety and the labor inspector was being paid off by the, or rather the factory inspector was being paid off by the management to keep silent, and you become the IRP today. So the management says to that inspector, boss, I can't pay you anymore. अब तुम इसको पकड़ो. So he comes today and tells you non-compliant hai, I will prosecute you. Okay. Now you have just taken over and you get this notice. You have taken over and you just get this notice, and you're running helter shelter. Within 1 month, In 1 month, you are supposed to form the COC. In 1 month, there is practically no oversight, and you are harassed like this. So
No, you have, yeah.
ideally, the law should change to say that for 1 month, till the COC is formed, ISP should not be burdened with all this.
No, but you have a point and you're right about it. I think for the previous action deeds, to collection of that, even that, it will not happen. It may not happen in some cases. A few steps which were supposed to have been taken by the previous management have not been taken, cannot be, probably of, not rectifiable nature probably. So the music has to be faced by RP. That's unfortunately that's the way it is. So what to do?
Majority of the things have been disturbed by the word suspended management.
Yeah,
Just by
yeah, yeah,
getting the word suspended, they put their hands up and they
yeah.
blame for everything to the resolution professional who is managing the operation. I've seen many of the cases, they don't even bother to sign the financial statement with this
I
fact that
think I think word is not suspended management. I think suspended board. I
it's
think board is
suspended
suspended.
board.
So
So
I think
as this
board has
suspension is,
more meaning
this
to it than
suspension is qua power and not duties. But they
yeah,
assume that duty comes to an
yeah, sure. I think that's something which has to be looked into. Probably will be looked into as it gets more mature over a period of time. Probably.
would like to take up the things from where it was. So, as far as the duties are concerned, we have seen, and again, I must say that this is just a cold print because we have seen the practical difficulties which are being expressed or which are being discussed by the eminent RPs or the eminent IPs, I must say, at this forum. So, as far as the duties is concerned, it is to protect the assets of the corporate debtor, including continued business operations of the corporate debtor. But I said, and just now we have discussed that what are the factors which are responsible for not keeping the company as an operative. There are many other aspects which are come between. So, as far as the duties are concerned, I, being an RPI, it's my duty to take the custody and control of the asset of the corporate debtor, including the business record of the corporate debtor. Represent on behalf of the CD with the third party. And again, this question comes that the moment I will be the one, the moment I will be the face of the company, ultimately it's me who will be blamed for, or who should be just for the compliance or non-compliance. Exercising right for the benefit of the corporate debtor in judicial, quasi-judicial, and arbitration proceedings. And I believe the much of the time of the RP is being spent in this. Raising interim finance, and we have seen that who is going to finance. My existing lender, as very rightly said, are not going to lend me further. Neither they are interested to take up the equity of the entity so that company can bring back on its feet. Even if once get revived, they may be the last one to lend to this entity which has just faced CIRP. So as far raising of the interim finance is concerned, I don't know this concept is going to groom or not, and which lender or what products are going to be brought in by the financial institution taking care of their interest during the course of CIRP. Appointment of accountant, legal professional. So maintaining an updated list of claim or convening and attending all the meeting of the COC, preparing IM. So I believe as far as the IM is concerned, that is going to be the backbone, or that is going to be the root or the fundamental document on the basis of which any success story of the CIRP procedure can be built up. Inviting prospective resolution applicant who fulfill such criteria as may be let down by him with the approval of the COC. Present all the plans at the meeting of the committee of creditor. This is something which is very recently changed. Present all the plans at the meeting of the COC. Earlier, only those plans which are compliant when being placed before the COC. Now, all the plans is going to be placed before the COC, and the opportunity will be given to the COC to direct that RA to make the modification so that the plan gets complied. So now it is all the plan which the RP has received from the successful or from the resolution applicants, the final list in the resolution applicant, whatsoever the plan received by the RP, it's RP who need to place it before the COC. Now, apart from section 25, it is 28 which is relevant. Now, here it is the power as far as the COC is concerned. Now, raising interim finance, it's a COC who is going to decide in its meeting security interest over the asset of the corporate debtor, changing in the capital structure. I've rarely seen this, that capital structure are being altered during the process of CIRP, because who is going to fund or who is going to finance the entity? Record any change in the ownership interest of the corporate debtor. Again, I have not seen during the course of CIRP the ownership in terms of the shares are being changed. Giving instruction to the financial institution maintaining accounts of the corporate debtor for a debit transaction from any such account in excess of the amount. Okay, undertake any related party transactions. This can only be possible if the company is going concern. But if it is, then in that case, to entering into a transaction with a related party, and I have seen many of the related parties are right now, you can say, are hiding behind the scene because of that PUFE transaction applications, which are always, and it's something which I believe that this again a mere theory. Amending a constitutional document, how difference it is going to create during CIRP. But yes, during CIRP, if any of these documents are being amended, it is the COC who has to decide, delegating its authority to any person. Dispose of or permit disposal of the share of the shareholder of the corporate debtor and their nominee. I have not seen, because ultimately it is the paper, a piece of paper, who has lost its value. Making changes in the management of the corporate debtor or its subsidiary. I believe, as far as suspended board is concerned, when the management is ultimately in the hands of the IRP and the RP, in that case, there is no difference it is going to create whenever, even if a change in the management may take place, transfer rights or financial debt or operational debt under the material contract otherwise than in ordinary course of business, changes in the appointment or terms of such personnel as may be decided by making changes in the appointment or terms of the contract of statutory auditor or the internal auditor of the company. Anyway, so this is certain power which are in the hands of the COC to decide. As far as 29 is concerned, and I'm again and again repeating that how important this document is going to be, but its completeness depending upon how well you are equipped with the information, how well you are equipped with the asset, how well you are equipped with the finance, how well you are equipped with the ultimate overall information and documents, or you can say asset or liability, or the background of the corporate debtor. So it's a RP who shall prepare the IM in such form and manner as containing such relevant information as may be specified by board. We are going to see the regulation in that word. Resolution professional shall provide to the RA access to all relevant information in physical form, electronic form. Anyways, this is again not so relevant as far as this subject is concerned. I must reach out to section 32 here, which is,
Sir,
yes, sir.
if you see the whole, what you were reading out that section 28, of course, it became a good refresher.
Hmm.
If you see, the COC is actually vested with all the powers of a board of directors. Structure, the restructuring the capital structure and all these kind of things. So in effect, they are supposed to do all the functions of a board of directors. They can take a decision. So the question is, they have no responsibility. So why would they do that?
Correct.
ये जो इतना सब है, यही तो बोर्ड ऑफ डायरेक्टर्स का रोल है ना.
यही बोर्ड और शेयर होल्डर्स का पावर है, बिल्कुल.
हाँ, तो अगर वो शेयर होल्डर और इसका पावर दोनों इसके पास चला गया, क्रेडिटर के पास चला गया, पर उसके पास कोई जिम्मेदारी नहीं है. He has no responsibility.
And
So
that's why I've
that
seen many of it was just you can say for the sake of visit. I visited 28, but I've seen majority of the powers have never been implemented.
ये तो भूल ही गए सर. आपने पढ़ा दिया फिर से अच्छा है. इतना जो सब चीजें किया जा सकता था, ये तो सब भूल गए. कोई करता ही नहीं. I am sure most RPs would have forgotten all this. And COC
But
ने पढ़ा भी नहीं
again,
होगा.
sir, there is no purpose behind. During the course of that CIRP, who is interested in buying out the shareholding or you can say shareholding of my few shareholder? Or what is the purpose it is going to create, or what difference it is going to be created if I'm going to change the management of that corporate debtor during that procedure? What is the purpose I will be changing the constitutional document of the company? What is the purpose I will be entering into a contract with a related party who is facing the similar heat from me in 66 or 43 application?
None really, but they have drafted it that way. Only thing
Correct.
is, so basically, I think they have taken, lifted the whole responsibilities of the board of directors as well as the shareholders and just exposed that into this act.
Correct, sir.
तो थोड़ा कट पेस्ट जॉब किया है. विदाउट मच लॉजिक थोड़ा सा कट पेस्ट जॉब किया है और ये सब सी देखिए इफ आई रिमेम्बर करेक्टली व्हेन आई started off in this profession 29A was not there. Okay,
Right, sir.
29A was not there. So I understand the logic was that yes, businesses fail and businesses should be allowed to restructure uh, by the way of a CIRP. Then I guess it became a political hot potato.
Hmm.
Like if SRs were to, uh, write off their 40,000 crore debt and give 10,000 crore and do the restructuring, it would become a very great scandal. So this 29A was brought in. The moment the 29A was brought in, then that whole concept of restructuring by the same management went off
Correct.
because you actually debarred the management from, doing the banks and the management. Nobody will do the restructuring, right? So the whole idea of IBC was to allow a restructure.
Correct.
And that should have been between the negotiation between the management and the
Lenders.
lenders. And it was supposed to get a sanction of the NCLT so that, uh, so what you call PPIRP right now. So
Correct.
this 29A, which was inserted in a very hurry-burry manner in my,
And I believe that 29A introduction is one of the reason this suspended management has become alien enemy to the RP.
so that is obviously when I had a case, one of my first cases, when before this 29A came in, I was very welcome by the management.
Correct.
The moment 29A came and they realized that they cannot, get back their company,
Correct.
why would they cooperate?
Correct.
So taking control and custody, one thing which we were discussing. Now, how many times are you effectively able to take control and custody? And you're supposed to immediately take control and custody. You have no financial resources and you don't even have a COC. And you are expected in the first month itself to take control and custody of all the assets and all the records.
Right, sir. Right.
How are you supposed to do that? Practically, it's not really possible. See, well, if you are a RP of a large company and there is, of course, you are backed by a good system, everything is fine. But there are 10 plants all over the India. So you go and you put your people there and you put your, you know, you try to take control. Very difficult.
Correct.
So something has to be reimagined in this whole thing. Some amount of powers need to be, some kind of a joint control need to be given to the management and the RP. So
Absolutely. Absolutely, sir.
some kind of a joint responsibility, joint this thing should be there,
And
and
I
the
believe that absolutely
control of lenders should be only to the extent of just approving the resolution plan.
correct.
And coming to PUFE, then that's again a problematic thing because this forensic audit, if it had to be done, it should have been done by the lenders, no?
And
Today,
it
you,
should have
I,
been done by the lender at that relevant point in time when the loan was
point in
disbursed.
time, point in time. So that is never done. Now you are just forced to file a
Correct.
PUFE most of the time. Of course, when there is a genuine this thing, I have filed PUFE, many PUFEs. The liquidation is already over. I started it in the CIRP, then went on to become the liquidator finally. I have sold off all the assets and the PUFE transaction application is still going on. Because somehow the other the management is able to buy time.
Correct.
So somewhere it's not working. Well, the system, maybe it needs to be reimagined a little more. And the parliament as well as the regulator may need to be a little more pragmatic, you know, rather than what I could say, trying to be politically correct.
And this is the biggest takeaway of this particular discussion, that the moment 29A restrictions or the hurdles will be out, the management, the erstwhile management, will be the first interested party for getting their seat back. And I still believe, in spite of all odds, the lenders are first comfortable to lend because they know the history. They have already tested the cream in the good days of the corporate debtor. Lender will be more comfortable lending the entity with the same management if this revival take place. Once revival take place, it should go in a dominance of both the suspended management, COC, and yes, the driving force is going to be the RP and ultimately the adjudicating authority. I must say that if this thing, or if this, or the confidence among the erstwhile management will come back, if this 29A hurdle will be out, the ultimate objective of the code is going to be survive, or that is going to be promoted. That is, again, I believe, I may not be correct, but I believe that the only reason the management is opposing me, objecting me, non-cooperating me, not providing me the information is this only, because they know that they are already out of the threshold. They are totally disqualified as far as, or their eligibility is concerned. The eligibility is established already, that they are no longer a person
And
who can vote for the entity back.
also by providing you all the correct information, you are going to file a PUFE against them, more
Correct.
stronger PUFE.
Correct.
So, see, there is a basic principle of law. One cannot be forced to incriminate oneself,
Absolutely.
right? So here you are asking the management to provide all the information of all their wrongdoing, which you are going to ultimately use to, you know, ultimately use to implicate them only. So there is a lot of sometimes it is funny, but there is a lot of this thing, lot of contradictions in the law.
And now the promoters are being educated. See, they have already faced, or their friend or their circle or their group somewhere have faced this kind of trouble. And now, if suppose if the things are coming to my court and my company is in CRP, I will be the first person hiding away from whatever may be the questionnaire, because we know 19 applications are not being so much. What is going to be?
Absolutely.
Yes, sir.
As a matter of fact, 19 application, when you file, the NCLT seems to get irritated with you.
Absolutely.
And I am your officer. I come to you with a genuine grievance. Ki boss, the management is not cooperating. Huh? The NCLT looks at you as a adversary. See, what have you done? What am I supposed to do? I don't even have the power of a labor inspector, you know, to
Correct.
enter the factory and cause these things to be produced to me. Do I have any quasi-judicial power? None. You can write to everyone to give the information. Yes, I have written. But if they have not given, then what am I supposed to do? One thing you can do is when you file 19, you should also file under the penal sections.
Correct.
Suppression of information. Now, what happens when you seldom do that because you still hope that कहीं कुछ तो cooperate करेगा बंदा और कुछ मैं चला लूंगा, resolution ला दूंगा. That's your objective. So you don't want to entirely antagonize the management. Otherwise, you can, if they are not responding to you, you can also invoke the penal section 77 and all those things, along with section 19, the suppression of material documents.
Sir, the kind of discussions we are having today,
Hmm.
don't you think we should discuss the trigger point of IBC? Where there is a debt which is due and there is a default, IBC is triggered. See, if
Absolutely, sir.
the correct now, sir, there are some
Absolutely.
units where the assets are so much than the debts, and they are going into CIRP or liquidation, whatever you can say. If they were say very fine to go as a going concern, they want to go. They should have been the problems for say temporary phase of business. They could not pay the installments, and they have gone into liquidation. Sorry, insolvency and IBC and liquidation. So if that there was a reference to change the act, this point should also be looked in.
The act, in my personal view, sir, act needs to be reimagined.
Hmm.
I've been practicing since
Specifically, sir,
2017.
trigger point of the IBC, trigger point of
No,
insolvency.
tell me something, sir. If the my whole thinking is, if at the first signs of the stress, when let
Hmm.
us say the first defaults happen, okay,
Hmm.
uh, ideally the bankers should take it to IBC around that time. Still, the management remains eligible to participate, right?
Correct.
Hmm.
But bankers will typically try to restructure, give them some more loans, you know, and
They are simply
like
interested in their NPS, number of NPS, sir.
precisely.
Hmm.
So precisely, sir, I'm not saying that in that many words, but they don't want to show NPA. So the first thing, if it is an NPA, you recognize it as an NPA and initiate the so-called restructuring there and there.
So
If
there may
somebody
be a
is,
temporary phase in business. See, for
hmm,
example, steel companies, there were a lot of dumping from China. Steel companies went into stress. Correct. There is a temporary phase due to government policies.
true, sir, true, but then the default has happened. Now, if
Yes,
the
default
default
has
has
happened, but
happened,
then the bankers, the lenders, they should address it then
no,
and
no,
there.
that's what I'm saying, sir. If you
Mm,
address it then and there through the IBC mechanism and you
mm,
do the restructuring and you have a
mm,
approval of the NCLT to a restructured uh, to the restructuring,
mm.
then it is a happier situation rather than waiting for the whole thing to go so bad
Vinit
and
sir
then
made.
you. Hmm.
Yes, yes, please go ahead, sir.
So this is my feeling. Of course, Vinit sir can say that the IBC, in my view, should have been invoked or should be invoked when the stress sets in. Not
Absolutely.
Sir,
So primary default, or the you can say, it should be during the course when lender has faced the first default, or they have faced the first
yes.
issue pertaining to the operations of the debtor. Absolutely right, sir.
the reasons why he failed, sir. And you made a reference before going into this expression of interest for RFRP or whatever. And the unit is
Sold
sold
as a
some
going concern. Yes,
going
sir.
concern. I mean, there should have been that problem should have been addressed then and there, sir.
Absolutely. So that is my thought process, because I
Mm,
think that is going to be the entity which can be freshly sold out. There will be a
mm.
less number of litigation. The round of litigation must have not been started, and that is probably the right stage wherein I can able to fetch the maximum value.
करेक्ट सर पर बिजनेस में लॉसेस होते हैं सर गवर्नमेंट ऑफ इंडिया की जितनी यूनिट्स है 90% लॉसेस में है
Correct, sir.
वो भी तो एक पॉइंट है सर
वैसे उनको भी आईबीसी में लेके जा सकते हो. कोई बार नहीं है।
हाँ।
वो तो कर ही सकते हैं सर, गवर्नमेंट
सर
की कंपनी है तो लेके तो जा ही सकते हैं।
सर बिजनेस में लॉस होता है।
नहीं
दिस
होता
इज
है ना
दिस
सर,
इज
बिल्कुल होता है।
कैरेक्टरिस्टिक ऑफ बिजनेस. It cannot always it always not in
सर क्या
profit.
है, आईबीसी को इसीलिए मेरे हिसाब से इनिशियली बनाया गया था कि
हाँ,
बिजनेस रिस्ट्रक्चरिंग करने के लिए इजी पड़े, एंड एक
हम्म,
लीगल क्या कहते हैं ना, लीगल जमा, लीगल क्लोजिंग पहनाया जाए उसको, रिस्ट्रक्चरिंग को।
हम्म.
बट उस लीगल क्लोथिंग में से प्रमोटर को बाहर कर दिया, वहां
हाँ,
पे
वही
प्रॉब्लम स्टार्ट।
प्रॉब्लम आ गया, उधर प्रॉब्लम आ गया। तो पहले पहले मुझे तो लगता है आगे जाके, if they really do this PPIRPs and all that, make it applicable to the other companies,
करेक्ट,
ideal situation should be at the first signs of default or stress, which the
करेक्ट।
bankers are supposed to come to know. Okay, so वहां पे आप ये करिए, वहीं पे आप शुरू कर दीजिए रिस्ट्रक्चरिंग। हाँ, इफ यू कम अक्रॉस दैट पर्सन हैज डन फ्रॉड, तब तो अलग बात है, तब तो देर आर सेपरेट सो मेनी अदर।
Sir, one very major concern in terms of fraud or PUFE transaction, the same auditor who was the statutory auditor or the whatever, the auditor who was there in the company since last 4, 5, or 15 year, the same person is being continued as an auditor during the course of CIRP. At this moment, he is questioning the transaction, whereas in the past he has given a very clean report, having no observation or having no reservations or remark. Now, how much that can be relied upon?
But sir, I understand the first thing that one needs to do, at least in my cases, I have changed the auditors.
Correct.
I have changed the auditors because the statutory auditors, of course, I had many legacy cases where the things were pretty bad only. So the auditor would also not cooperate, saying मेरा पहले का फीस दिया नहीं है,
Right.
so I will not give you information and things like that. And they used to even say that, boss, I have done the audit at the premises of the company only, the data are not with me. A couple of cases in PUFE, I have made the auditor also a party, saying that, but then problem happens is none of the PUFEs have really seen the light of the day in my case. So technically, I have 10 cases in my name. Only five liquidations are going on. Rest of it is all PUFE only I am fighting. And where the four successful resolutions happened, of course, 5 cases I am a liquidator. I took it at the liquidation stage.
Mm.
Uh, where the where I was the rest of the cases, 4 successful resolutions have happened. In all the 4 successful resolutions, the creditors were supposed to pursue the PUFE application. And I'm rather sarcastically saying that I'm happy to note in all the cases, the applications have been dismissed for non-prosecution by the creditors. In one case, I was still following up. Uh, then the NCLT told me, "What is your locus standi?" I said, "Thank you, sir. I'm going." So, so this is what happens. So PUFE, I don't think now it
PUFE
has become
is
a
not
hot
an asset.
potato.
PUFE is not an asset of the corporate debtor. That is something which should be now digested, because it only adds a cost in terms of that procedural delay, in terms of that transactional audit fees, in terms of forensic audit fees, in terms of my advocate fees. It's a liability rather than asset, and there is no fate to that transaction.
And and most of the cases, they are many a times, the reports are not conclusive. You know, reports are not conclusive. Then NCLTs will come and say you are supposed to apply your own mind.
Correct.
Management will say कि RP has not independently formed his opinion. Now I have hired a transaction auditor. He has given me a transaction audit report X or Y. Now if I am not supposed to rely on his report, then why do I get a transaction audit done in the first place? And why every RP is not an auditor,
Correct.
but it's the RP's duty to form an opinion. From where? You don't have the data. See, many a times you can make a forensic report, right, looking at the bank statements itself. Uh, but if you don't have much data, particularly slow moving stocks and things like that, the auditors have seldom qualified them.
Correct.
And then you are starting to point them out. I don't know. Pufe also probably maybe, but actually the government or the parliament will have to decide, do you want the RP as a prosecutor or do you want the RP as a resolution fellow? Resolution and prosecution cannot go together.
Cannot go together.
Both the roles need to be separated. So ideally, the resolution professional, if he's supposed to be the find a resolution applicant and all this kind of a quasi merchant banking kind of a job, he should be allowed to concentrate on that, and the responsibility for PUFE or this thing should probably be, put onto the committee of creditors. You get a forensic audit done.
Correct.
Means my experience, that's about it. I mean, sorry, if anybody disagrees with me, of course, I'm always open to. We are all here to learn from each other, but this is what I have faced. So मैं आप बीती बात बता रहा हूँ. Many professionals would have had very good experience also, but this is my experience.
And I believe this is a common experience because what I can make out of it is the provisions are very much impractical in nature. Whatever we have seen, the latest one, Section 28 itself, very impractical in nature. And I believe that, and I still agree to this, 29A has made a big difference between big it's made a big breach between the promoter and the corporate debtor, a big breach. Otherwise, I believe still the first person who want to revive, with whatever may be the selfish motive, with whatever may be the intent, but the first person who is willing to revive the entity and the first person who is willing to get back on its seat is the suspended management. I would like to touch upon again the regulation side of this code, because now again when we see the regulation side again, there are several provisions which are talking about that what efforts to be made to bring out the maximum realizable value for the corporate debtor, even though it is sold as a, or even if it is going to be sold as a going concern. And much efforts will be made before that to get a plan for the company and to sell out the company through the resolution plan only. So I'm just sharing the screen for the sake of convenience. But yes, it was Section 32A, which was the last point of discussion as far as the code is concerned. And that is a lucrative thing. The only thing which is a motivating factor for any investor to come in, jump in, and to bid for a company which is CIRP. But again, when we see 32A, that is again having a direct linkages with 29A, and here the promoter is not getting the immunity, he is getting the company back. So I'm sharing the code again for the sake of 32A, and then we will be dealing into the aspect of the regulation. So this 32A, which clearly talks about the liability for prior offense. And because of when you read 29A, when you read 32A, there is no motivation for a promoter or the erstwhile promoter or the suspended board to bid upon or to think upon this entity to get it back through the resolution plan. So, notwithstanding anything to the contrary contained in this code or any other law for the time, the liability of the corporate debtor for an offense committed prior to the commencement of CIRP shall cease. corporate debtor shall not be prosecuted for such an offense from the date of resolution plan approved by the adjudicating authority. And 31, if the plan results in change in the management. Now, this is something which is again a factor which is not in so favor with the management taking over the corporate debtor. If the plan results in the change in the management or the control of the corporate debtor to a person who was not a promoter or in the management or control of the corporate debtor or a related party to such person. So I believe that again a setback, if we see from the perspective of the last discussion what we had, that what 29A has impacted my code. A person with regards to whom the relevant investigating authority has, on the basis of the material in its possession, reasons to believe that he had abetted or conspired for commission of an offense and has submitted or filed a report or a complaint to the relevant statutory authority or court. So I'm not going into it, but I'm very much stick to this part that it's a clean slate theory. Now the question is whether the same clean slate theory will apply to a person who is purchasing a company as a going concern on the basis of as is where is basis, whether the same clean slate theory will will be applicable to the bidder, to the purchaser or not. That's an important point. But again, this is not so in favor of the person, that even though if the company is taken over by the resolution plan, but if the resolution plan results in the change in the management or control of the corporate debt to a person who was not. So if the person is a promoter or in the management or control of the corporate debtor, no such kind of immunity will stick to it. Again, same thing which is there in subsection 2. No action shall be taken against the property of the corporate debtor in relation to an offense committed prior to the commencement of CIRP, where such property is covered under a resolution plan approved by the adjudicating authority, which results in the change in the control of the corporate debtor. Now, which results to the change in control. Now, suppose if the control survives, no such kind of immunity will be available. And from here, I would like to go to the regulation side. Now, as far as this regulation is concerned, that is Insolvency and Bankruptcy Board of India Insolvency Resolution Process for a Corporate Persons Regulation, which has been amended from time to time, or there are multiple changes which has taken place. But first to deal upon is Regulation 3A. As far as Regulation 3A is concerned, which is talking about that assistance or cooperation by the personnel of the corporate debtor, and we had a large discussion or a very healthy discussion on this part, that if this code is not friendly with me, if the code is having no such kind of privilege to be given to me, if I will be the one who is going to cooperate on the one side and I'm going to be the one who is going to be prosecuted, or I will be the person who is going to be impacted out of my own sharing of information, then this assistance and cooperation will not ultimately going to benefit me. So this is what Regulation 3A, but otherwise it talks in the same line of what we have seen in section 19. Other regulation is Regulation 6, which I would like to deal upon, having some relevance to the subject. So it's a public announcement, and this public announcement which clearly states that within 3 days I have to give a public announcement, and one has to put his claim within 14 days from the date of this initiation of CIRP. So it is 14 days from the date of appointment of IRP. I must say it should be from the date of commencement of the CIRP. I have to submit my claim. Where it is not possible to send a communication to the creditor, public announcement made under Regulation 6 shall be deemed to be the communicated to the creditor. So I believe this has given a extra benefit or a privilege, or I must say a liberty to the RPs or the IRP basically. Otherwise, it is mandatory. So it is very clearly stated that where it is not possible to send a communication to the creditors, then public announcement under Regulation 6 shall deem to be the communication to the creditor. But otherwise, it clearly states that so if it is possible, you should communicate to the creditor. But again, how it is going to impact the process? I believe considering a very limited time within which I need to take the custody, I need to constitute a committee, I need to call the meeting of the COC, and that given time of 30 days, if I'm going to communicate to the creditor, ultimately there is no benefit which I'm going to get. As far as regulation 27 is concerned, which is relevant as far as the subject matter of discussion is concerned, appointment of professionals. RP within 7 days of his appointment, and this is talking about the registered valuer. RP within 7 days of his appointment, but not later than 47th day from insolvency commencement, appoint two registered valuer to determine fair value and the liquidation value of the corporate debt in accordance with regulation 35. But as far as the valuation will be valid up to what? Within what time this need to be reevaluated, reevaluated, revalued? It is something which is, I believe, is not there in the regulation as well. 29, sell of assets outside the ordinary course of business, and how you can then maintain the overall valuation of the company. And this is what we had a discussion earlier, that recent amendment of 2025, which is there on 26th May, when I will be in a position to invite EOI for singularly for all the asset of the corporate debtor. Of course, as may be decided by the COC, if I can invite plan, or if I can invite by the way of expression of interest, if I'm inviting plan on asset basis, then ultimately whether the company will be able to fetch its overall value or not, that is again a point which is going to be a part of deliberation or discussion. But selling of the asset outside the ordinary course of business, RP may sell unencumbered asset of the CD other than an ordinary course of business if he is of the opinion that sell is necessary for better realization of the value under the facts and circumstances of the case. Sale of the asset under this regulation shall require approval of the COC with 66% voting share. A bona fide purchaser of the asset sold under this regulation shall have free and marketable title to such asset, notwithstanding the terms of the constitutional document of the corporate debtor shareholders agreement, joint venture agreement, or other document of the similar nature. So this is again giving that regulation 29 is giving an age to the RP to decide whether if any of the asset is having some realizable value, can it be sold or not. Now, as far as this regulation 29, which section 29, which we were dealing into the aspect of information memorandum, and corresponding regulation, if I can see, it is regulation 36, which I believe is important. And as I said, that this is the fundamental document to be relied upon by any outsider when that outsider will be interested to place his plan for the company. Regulation 36. Subject to sub-regulation 4, the RP shall submit IM in electronic form to each member of the COC on or before 95th day from the insolvency commencement date. The information memorandum shall highlight the key selling proposition, contain all relevant information, which serve as a comprehensive document conveying significant information about the CD, including its operations, financial statements. To the prospective resolution, applicant shall contain the following detail of the corporate debtor, namely assets and liability, including contingent liability, with such a description as on insolvency commencement date as are generally necessary for ascertaining their values. Latest financial statements, audited financial statement of the CD for last 2 years, provisional financial statement for current financial year up to the date not earlier than 14 days from the date of appointment. Practically not possible. Who is going to prepare? Management. Who is going to sign? Management. If it is audited, who is going to sign? Auditor. And are you going to get this relevant information and assistance within a given time frame? List of creditor containing the name of creditor, amount claimed by them, amount of their claim admitted, security interest if any in respect of the claim, particular of debt due from and to the corporate debtor to the related parties, detail of guarantee that has been given in relation to the debt of the corporate debtor by other person, name and address of the member or partner holding at least 1% stake in the corporate debtor along with the size of the stake, detail of all material litigation and ongoing investigation or proceeding initiated by government or authorities, number of worker or employee and the liability of the corporate debtor towards them, company overview including snapshot of business performance, key contract, key investment highlights. So basically this is a document which is comprehensive in nature, and these are just the indicator what you need to provide or what you need to detail in. Business evaluation, industry overview, key growth drivers in case corporate debt having book value of the asset exceeding 100 crore. So basically, this is a document which is going to be the fundamental on the basis of which a person may not be proposing a plan for. A member of the committee may request the resolution professional for further information of the nature described in this regulation, and the RP shall provide such information to all the member within a reasonable time. Creditor shall provide to the RP the latest financial statements and other relevant information of the corporate debtor available with them. Creditor will provide. RP shall share the information memorandum after receiving an undertaking from the member of the committee to the effect that such member RP shall maintain confidentiality of the information, inviting EOI. So it is 60th day, and as we studied this, that now the RP with the approval of the COC may invite EOI for submission of the plan for the corporate debtor as a whole, or for sale of one or more of the asset of the corporate debtor, or for both. This is going to impact the timeline in true sense. Last date of submission of the expression of interest, that should be within 15 days from the date of the EOI, that is 75th day. RP shall issue a provisional list. So basically it is a 60th day and 15 days within which the EOI need to be submitted within 10 days thereafter. So up to 85th day, the list of provisional RAs will be available, and I will be giving a time frame of 5 days to the objector whose name is not there in the RA. And thereafter, so on completion of 90th day, I will be giving a final list of the resolution applicant up to 100th the day. So this is what is provided: 60 plus 15. Thereafter, within 10 days, so up to 85th day, it's a provisional list of the RA. Will be giving an opportunity to those whose name is not in the RA, so that their objection may be considered, regarded, not regarded within 10 days thereafter. So after 90th day, within 10 days, so up to 100th day, I will be placing the final list of the RA, and I will be giving them a request for resolution plan. So this is very much a theoretical portion which I don't want to delve upon. The RP may, with the approval of the COC, reissue request for resolution plan if the plan received in response to the earlier request are not satisfactory, subject to the condition that request is made to all prospective RA in final list. Provision of subregulation 3 shall not apply to submission of resolution plan under this subregulation. Strategy for marketing of the asset, anyways, this is not so relevant. Plan, I'm not going to touch upon the plan side, but yes, regulation 36A onwards, I believe, is a relevant regulation to be taken care of first. Regulation 36A, 36B, 36C. – 39B is relevant. So as far as this 39B is concerned, now this is relevant wherein it is the COC who ultimately used to decide where to drag the corporate debtor for liquidation, whether not for a liquidation, whether plan can be approved or not. So it's meeting liquidation cost. While approving a plan under subsection 4 of section 30, or deciding to liquidate the CD under subsection 2 of 33, it's the COC may make a best estimate of the amount required to meet the liquidation cost in consultation with the RP in event of an order for liquidation is passed under 33. So it is one of the parameter for the COC to decide whether, if company drags into the liquidation, what is going to be the liquidation cost, from where the liquidation cost can be made out. So while approving the plan or deciding to liquidate the CD under 2 of 33, committee may make a best estimate of the amount, required to meet the liquidation cost in consultation with the RP in the event order of liquidation is passed, based on which the committee shall make a best estimate of the value of liquid asset available to meet the liquidation cost. Subregulation 3, where the estimated cost of the liquid asset is less than the estimated liquidated. So estimated value of the liquid asset is less than the estimated liquidation cost, the committee shall approve a plan providing contribution for meeting the difference between two. Now, this is the assessment of the compromise and arrangement. That is, again, I believe, a theory which is not so working practically, because as far as the compromise and arrangement is concerned, now it do have a genesis under the Companies Act, the provision of section 230 and section 232 read with compromise, arrangement and amalgamation rule, which talks about as far as the mergers are concerned or the amalgamation are concerned or any sort of compromise and arrangement with the member or with the creditors of the companies are concerned, it requires the approval. It requires the approval of the creditor, it requires the approval of the member, and whose approval is required? The creditor consent, majority holding 3/4 in value. Now, on one side, now there is always a question, a resolution plan which has not, or the COC who has not passed the resolution plan. The resolution plan gets failed because the COC has disapproved it. Now, the same class of creditor, the same creditor, but again, when I say the compromise or arrangement, it will not only confine to the creditor who are just in the committee. It will cover all the creditors then. It will cover all the creditor, including my operational creditor. That is what I believe, as far as the scheme of compromise and arrangement is concerned. But again, how successful this is again a subject matter of question which vary from case to case. But yes, while deciding to liquidate the corporate debtor under 33, the committee shall examine to explore the compromise and arrangement. I believe the same committee who has recently disapproved the plan, while deciding for a compromise and arrangement, they're holding their say will get diluted with those creditor as well who don't hold any locus in the COC, because Companies Act does not differentiate between a related financial creditor or the related creditor and unrelated creditor. So how far they will be more keen for dragging or to decide that this company may be revived by the way of compromise and arrangement, it's again a subject matter of question. So while deciding to liquidate the CD under 33, the committee shall examine whether to explore compromise arrangement as referred in subsection subregulation 1 of regulation 2B of the liquidation regulation, and the RP shall submit committee recommendation to the adjudicating authority while filing an application under 33. Where a recommendation has been made under subregulation 1, the resolution professional and the committee shall keep exploring the possibility of compromise and arrangement. But again, there is a side effect of this is the one not eligible under 29 is not eligible to propose a scheme for compromise and arrangement. And this is what provided in regulation 2B of the IBBI liquidation process regulation. Assessment
So,
of sale as a going concern. Yes, sir.
so the compromise and arrangement, if you look at from the company, right? Now, who can bring
Sir,
a compromise?
sir,
The same
your
promoter.
voice was,
Yeah, what I am
you're
saying,
audible.
sir.
Yes, sir.
Yeah, what I am saying, sir, the compromise arrangement was envisaged in the Companies Act, uh, saying that any stakeholder can come for a compromise, right? Any
Correct, sir.
stakeholder. Now, here, if you remove the promoter, because he is not eligible under
29.
29A, then effe- then effectively you are killing the
The rationale.
killing this whole provision altogether. Irrational.
Correct.
So I guess it's time
Yes,
that
yes.
a
Every
pragmatic,
every provision and every regulation is forcing us to think from this angle. You're right, sir.
yeah. So basically, the whole problem in IBC, as it was envisaged and as it has shaped up, is because of this 29A.
Correct.
Because it is assumed that all businesses which are in default are necessarily fraud and cannot be, the same promoters cannot be given back those companies. And there is no depth in the market also. Ideally, there is no depth in the market. Who will take it? Today, best of the uh, Indian businesses, sir, are family run. Even if you take a big company like Reliance, all said and done, it's family run.
Correct. Correct. Correct.
तो कौन लेके आएगा उसका resolution if you remove them only altogether?
Right, sir.
So again, this 29A probably has to be now pragmatically dealt with.
Absolutely, and sir, as far as the nexus between Code and Companies Act is concerned, it is again a matter of concern. The reason is, if I go with a compromise and arrangement, compromise with whom? To compromise with my creditors. Compromise with whom? Compromise with my members. Compromise and arrangement always does not mean it is by the way of restructuring, by the way of merger amalgamation. Compromise or arrangement in any sense, which is governed under Section 230 of the Companies Act. Now, who will be dominating the thing? It's not COC now. It is now ultimate all the creditors.
Yeah,
Operational
true,
credit,
true. Every class of creditors has to vote, and
everyone.
that too by 75%, if I'm not
Correct.
mistaken.
Correct.
So how will that come around? I don't think.
Absolutely. So when their say is getting diluted, COC's say is getting diluted in the scheme matters, why COC would like to prefer or to force RP or liquidator to opt for a compromise and arrangement. And again, I must say, who you are going to get? The one whose plan got rejected by the COC? Because promoter are in any case outside the boundary wall.
True, sir. They need to really reimagine the whole act again. Or I think the fraud portion and the restructuring portion needs to be pragmatically segregated.
Absolutely, sir.
But you can't have everything under one code and put all the responsibility on one individual.
And you can't have PUFE application in all the CIRP.
Whether it's IPE as IP or individual as a IP, one and the same. As long as you have these provisions, it doesn't add up. Nothing else. It just doesn't add up.
Right, sir.
Yeah, please continue, sir. No problem. I just thought I'll.
So now this is the assessment part, section regulation 39C, wherein we are going to straight away discuss what is there in regulation 32A of the liquidation regulation. So while approving a plan under 30 or deciding to liquidate the CD under 33, the committee may recommend that liquidator may first explore the sale of the corporate debtor as a going concern. Under Clause E of Regulation 32 of the Insolvency and Bankruptcy Board of India, liquidation process regulation or sale of the business of the corporate debtor is a going concern. Now, this is something which, anyways, we will be discussing it or we will be dealing it in the liquidation regulation part. So, it is the resolution plan which, if not being approved, then while deciding this particular fate or deciding to liquidate the CD under 33, committee may recommend. So basically the role of the committee is just recommendatory in nature, that liquidator may explore the sale of the corporate debtor as a going concern. So here the liquidator is having a big say because ultimately COC don't have any dominance over the same. The committee recommends sell as a going concern. It shall identify and group the asset and liability, which according to the commercial consideration ought to be sold as a going concern. Now, the point is, if I just identify the group of asset, now what about the left out asset of the company? Because once I sell the company as a going concern, I cannot segregate asset of the company versus the company as a going concern. I cannot detach the asset versus the company's asset which are being sold as a going concern. The resolution professional shall submit the recommendation of the committee to the AAY filing and approval or decision of the committee under 30 or 33 as the case may be. And I'm reaching out to 32A before we conclude and before we seek the views from the learned IPs. It's 2B, 32, and 32A. These are the three relevant discussion as far as the subject matter of or this session is concerned. And recently, what we dealt upon is the compromise arrangement part. This is what the regulation was all about, which deals with this compromise arrangement, that is 2B, regulation 2B of the liquidation regulation, that where a compromise and arrangement is proposed under section 230 of the Companies Act, it shall be completed within 90 days of the order of the liquidation under 33, which is impossible. Which is impossible. I have not seen even fast track mergers are being concluded within 90 days. Provided that a person who is not eligible, now this is another problem to the code or problem with the code, that a person who is not eligible under 29A, who is not eligible under 29A of the code to submit a plan for CIRP, shall not be a party in any manner to such compromise and arrangement, in any manner. That the liquidator shall file the proposal of compromise and arrangement only in case where the recommendation has been made by the committee under 39BA of the IBBI insolvency resolution process. So only when committee has recommended. So recommendation of committee takes a big role. Liquidator shall not file such proposal after the expiry of 30 days from the liquidation commencement date. So again, the time limit is limited for the liquidator to decide. But again, that depends upon whether committee has recommended while moving an application for liquidation. The time taken on compromise and arrangement not exceeding 90 days shall not be included in the liquidation period. Anyways, we are concerned about regulation 32 and 32A. Now, as far as regulation 32 is concerned, that is deciding, or that is the manner in which it is being decided how a liquidator may sell the asset of the corporate debtor, which is in liquidation. On a standalone basis, okay, that is the overall process of liquidation all about. In slum cell, set of the asset collectively, asset in parcel, E and F are relevant. Corporate debtor as a going concern, or business of the corporate debtor as a going concern. I would like to have your views on that aspect. The moment this discussion gets over, the theoretical part gets concluded. So selling the company as a going concern, that is something which we can able to understand, but selling the business of the corporate debtor as a concern. Now, in absence of the business of the corporate debtor, suppose if I can remove a business from the corporate debtor, now what corporate debtor's life is going to be? And one is corporate debtor as a going concern, other one is a business of the corporate debtor as a going concern, and where the asset is subject to security interest, it cannot be sold under any of the clause unless security interest has been relinquished to the liquidation estate. So the secured creditors say on this procedure is having of big weight. Now, sell as a going concern, where the committee of creditor has recommended, I'm talking about the same regulation 39 that we were discussing. The committee of creditor has recommended sale under E or F of regulation 32. Committee, that stakeholder committee or the committee of creditor, or where the liquidator is of the opinion that sell under clause E or F of regulation 32 shall maximize the value of the corporate debtor, then he shall endeavor to first sell under the said clauses. For the purpose of sell under sub-regulation 1, the group of asset and liability, and here my question is, this is a very relevant question, because if I'm identifying the group of asset vis-a-vis liability of the corporate debtor, now what about the left out asset which is not forming a part of the group? Is a very relevant one, because if once I sold a corporate debtor with a group of asset and liability, I cannot detach, and this is my primary concern, is I cannot segregate or I cannot detach an asset of the corporate debtor without a corporate debtor. So ultimately it is the company as a whole with all the asset and liability I'm going to sell as a going concern. For the purpose of sell under
But
sub-regulation
how
1,
can you sell with the liability? What kind of liability are you talking about?
ultimately that goes with all the liability as what we used to see in IM, whatever may be the liability, ultimately my proposal will be coming accordingly. So whatever I'm going to take is the value of the asset, and against that value of asset, what I'm going to pay is the liability. So again, the same thing is coming in between. Liability including, I cannot, and how an RP or how a liquidator will decide that only this liability will be discharged by the way of sale of the company as a going concern. I
Precisely,
cannot,
Section 53 is there. No, Section 53. So basically, only assets or the company can be sold as a going concern. Whatever money you get, the wholesale consideration will have to be distributed as per Section 53 waterfall
but
mechanism.
now whether 53 will apply if I'm going to sell my company as a going concern is again a
It
question.
has to, because it's a part of the act,
But again, sir, this is
and
not a
this is a
liquidation.
regulation.
No, no, but
This is a Sir, this is a regulation. And Section 53 is the part of the basic act. Uh, a subordinate legislation or a regulation cannot override the act.
But again, during the course of liquidation, in whatsoever manner I liquidate, be it a voluntary liquidation or be it a liquidation after the failure of resolution plan, I need to abide 53 if I'm liquidating an entity. And as far as selling of the entity as a going concern, it cannot be parallelly stand out with a liquidation of the corporate debtor.
No, so then this whole thing need not be in the liquidation chapter at all. You're getting my point? If it is in the liquidation chapter of the IBC and it starts after the liquidation order is passed, it
Correct.
starts after the liquidation order is passed. So if the liquidation order is passed, then 53 comes into play. So my understanding is you can sell the company as a going concern, like say the business or the whole company, and whatever proceeds you get, you have to pay according to Section 53 in the same waterfall mechanism. You cannot give any priority to anything. You cannot say, Baba, chalo, electricity dues so that you can start. You can't do that. Legally not possible, sir. Because you cannot change the basic structure of the act itself, no, by one regulation.
But in that case,
That is
then
where the
in that
problem
case,
is. If they create a separate
I
Hmm,
understand, sir. I'm now
hmm.
taking that side. Then in that
Yeah, tell me,
case,
sir.
SRA and the bidder, the successful bidder,
Hmm,
are not standing parallelly. That means
hmm, hmm.
so SRA will
No,
be getting an edge over this
no,
person who
they
is
are
buying
not
the
supposed
company.
to. Absolutely, absolutely. And that is where that latest that judgment I was talking about. No, I'll have to take it out now. Just 3 days back, I read this judgment, which said the exact same reliefs and concessions that was part that can be granted to a what you call
SRA,
SRA
correct.
cannot be granted to the to the auction purchaser under sale as a going
Regulation
concern.
32, correct.
The NCLAT or I think in which bench the NCLT or NCLAT they differentiated it. They actually took some pain to differentiate it. It was a good judgment. Just forgot the name actually, but maybe
So correct. Now
ICSI.
that is raising another question as well, which I pointed out. If I have to identify the which group of asset and liability I'm going to sell it out. Now my question: if the corporate debt is sold as a going concern, the entire identity, the corporate identity is being sold out as a going concern. Now what about the left out asset? Is my question. I cannot detach an asset with the company, or its ownership cannot be detached just by the way of this procedure.
No, in which case, what you will have to do is you will have to form an SPV. You have to form an SPV and remove those assets into that SPV and those liabilities into an SPV. So it's easier said than done.
Correct.
You know that 90 days में तो हो ही नहीं सकता है.
मैं वही सर
If
वही बात है. Now again
90 days
SPV
में
is
तो
an entity, sir. So what about that entity which is being created by the way of SPV?
eventually that will be liquidated. So it doesn't add up. That's what I'm saying. These are beautiful ideas, but these are beautiful ideas only.
Absolutely, sir. It's ideas only.
It is an academic
Because I have
exercise.
seen in almost all the applications, the moment companies are being sold as a going concern, the other application which is being filed by the liquidators for the sake of discharge.
Yeah. Latest one order came. Okay. One order came. This is in case of one of my our partners only. So here the valuation of the company was very little because there were no assets, no tangible assets. However, there were some carry forward losses, and there was some sundry debtors recoverable and things like that, which the valuer at that point of time had valued at nil. I don't know how a carry forward loss can be valued. This is a very new thing. But how can we exactly say this is a carry forward loss and इसका ये value होना चाहिए आज? Because the carry forward loss is a tax planning, na? Whether the
Correct.
tax guy allows it or not. By the way, this thing, the liquidation value was, let's say, in lakhs. A auction notice or for sale of going concern was filed by by my colleague, and he got a plan for 2.5 crores. Okay, the sale went through. Sale went through. Now he wanted to close the process. NCLT turns out and says, boss, if it was having liquidation value of only this much, how come you got this much money? Okay, अगर 10 लाख ही था, आपको 2.5 करोड़ कहाँ से मिला? So
Lost.
when the हाँ, so when the counsel appearing for him told that there are certain carry of forward application, there is something like PUFE, little PUFE is pending and this and that. They said that means you have not valued it properly. So we will not let you close the process. आप इसका पूरा valuation करा के लाओ. Absurd.
Correct.
Now already the money is taken, money is distributed. The fellow has got the company also. It has been given to him. Now this question is being thought of by the honorable bench. कि ऐसा कैसा? And my friend is in a fix. So anyway, so अच्छा खासा मजाक बन गया और कुछ नहीं.
So ultimately, these are the beautiful ideas.
Yeah. Academics.
Because otherwise, the
Like now,
practical difficulties are there. Because apart from this regulation 32, there is no presence of going concern sale or the modus through which it can be sold out. Again, applicability of 53A, which is again a very interesting question. Now, again, to segregate the group of asset which are being sold as a going concern and the group or the parcel of asset which are not being sold out. Again, segregation of the liability qua that asset are some very interesting point on which there is no question or where there is no provision or there is no regulation which is settled. So in that case, as you suggested or as you have mentioned, that even the carry forward losses are being valued, and on the basis of that valuation of the carry forward losses, the companies are being sold out. This is what going to happen.
no, tell me something. Is there a concept in valuation where you can exactly give a value to a loss? Then it is not a loss, no?
Not a loss. Correct.
Supposing 200-300 करोड़ का कैरी फॉरवर्ड लॉस है, हाँ, अब उसका क्या वैल्यू लगाएंगे?
It's
How
only
do you know
healthy
कितन
company. Yes.
हाँ?
Only a healthy company who can able to evaluate this benefit of loss.
Precisely. So what figure will a what you call valuer give to a
Correct,
carry
sir.
forward loss? But NCLT is asking this question. The order said recently IBBI said that carry forward losses must be valued, which is not what IBBI said. IBBI only said the carry forward losses section wise must be mentioned
Correct.
in the IN, which is again, I wonder why. Why are you encouraging a tax arbitrage? In the name of resolution, why are you encouraging, as a regulator, why are you encouraging a tax arbitrage? if a if shell companies land up being bought like this, who is losing? The exchequer.
Correct.
पता नहीं. Now, this is a new latest order I saw today or morning only. I was just trying to figure out with my friend कि क्या जवाब देना है इसका. Because he has to file an affidavit. Tell me, sir, carry on. Will
That's it, said that was what we have concluded with, because this is what the topic wherein I'm selling the corporate debtor as a going concern, and I'm selling it with no clues around. So this is the biggest concern as far as why this is coming at this stage, and that too once the liquidation order is passed and not at that early stage, because it should be standing in front footing before I invite plan for my corporate debtor once not sold as a going concern, because I believe the company will get, and as you suggested, as you have mentioned, as you have opined on this as well, that why not at the time when the first default took place, why not the provision was invoked? And again, same goes with section 9, or rather section 9. I should not discuss section 9 at this discussion, because now that is going to be another level of, you can say, deliberation. But as far as the section 7 is concerned, for which basically this code mean to, why the lenders are approaching this forum at a stage wherein the company, basically the promoter is already disqualified, or are getting into the ineligibility lines. They are the one with whom you was in the coordination, or was in during the course of negotiation, by that application was not paid. So I believe that the entire structure, and as you very rightly suggested, that whatever is the provision of PPIRP, it should not be confined to few entities based on threshold. It should be kept open for all, so that, and that
Sir,
is one of the very good concept.
Even in PPIRP, the biggest irritant is the PUFE.
Correct.
You know, I would say in PPIRP, section 43, 45, and that extortionate one, 47, no, or something,
Hmm.
for uh, that should be exempt.
Absolutely, sir.
Only if 66 is there,
Hmm.
you prosecute.
Right.
Because tell me something, as a promoter, when your business is failing, it is
Hmm.
quite normal that you would probably take some money from your related party
Correct.
and then repay that fellow also.
Right.
So it will become 43 clearly, because your business is beginning to struggle. Before you default, you first take money from another healthy company into this company, and then you land up paying that fellow.
Correct.
But you have done 43. Now, if you're told to, reverse that. So this is normal business practice. So this 43, if you are doing PPIRP, at least 43, that is your preferential, and what you call preferential particularly has to be removed. Undervalued you can still question. Undervalued you can still probably question. But
Hmm.
this questioning should not be left to the
Preferential.
RP.
Correct. Correct.
प्रेफरेंशियल तो होता ही है.
होता ही है, बिल्कुल होता है. Because when there is no person to lend, it is always my own party who is going to grant for whatsoever
Yeah.
selfish reason. You're right, sir.
So, but that is something they have to remove, because you are asking the promoter to declare ना भाई मैंने ये preferential किए, and you are
Hmm.
going to prosecute him. क्या मतलब हुआ? Huh? Why why even in MSME, how many PPIRPs have actually happened?
Correct.
You can probably count on the fingers.
Right.
So anyway, unending debates unless and until they reimagine the act. They have to decide कि what is the act meant to do?
Hmm.
Is it to revive? And then, as you rightly said, if it is to revive, then why not the same promoter?
Correct.
Or is it to prosecute? These two duties I personally feel need to be segregated. This is my personal feeling, sir.
No, no, absolutely, sir. This is what we have rightly reach out to certain conclusion, which may not ultimately how what difference it is going to be create. Exactly don't know, but yes, every provision which we read ultimately we have seen how practical it is working, or it is just there in the code print. So I believe that 29A has made a big difference in the objective of the code. Selling a corporate debtor as a going concern at that belated stage, bringing EOI for individual asset of the corporate debtor, giving a locus to the this finance provider, fund provider, interim finance provider, giving no teeth in the COC is another issue which is going to impact the process at large. And no monitoring or no such kind of conduct or the code which is prescribed for the COC, there is no liability or the responsibility on their part. This is one of the key bullets which we have identified, which has ultimately impacted the rationale of the code.
So basically, as they say, they were saying, na, any law made in reaction is a bad law.
Hmm.
If you were to go by analogy, after Nirbhaya, the age for trying someone as an adult
Correct.
came down to 16 from 18. Did it have any deterrent effect?
Hmm.
Did it have any this thing? No. It was a knee-jerk reaction.
Correct.
So 29A, in my view, was basically a knee-jerk reaction.
Correct.
It's just a reaction. Whatever
Reaction.
you make, and much of the amendments or regulations that are coming out are basically out of reaction to something, not thoroughly thinking through. It's more like experimenting.
Correct, sir.
So thank you, sir. Thank you from
Thank
my
you very
side.
much, sir. Thanks for all your very informative inputs, and your experience reflects in such kind of forum wherein we as a very young speaker get necessary breathing part from this conversation, sir. Thanks a lot. Thank you very much, sir. If you have any concern or any such kind of discussions or any kind of point to be deliberated upon, we should discuss it. Otherwise, Anjali, we may sign out.
Where is Anjali?
I hope they are in the office because it's Saturday evening at 6 o'clock. I'm not waiting for. Thank you very much, sir. It's again wonderful to have this kind of interaction, and
No, there are 25 of us still present. Huh? I think 25 of us are still there in the. Uh,
I'm just waiting for coordinator to come and conclude. Otherwise,
No response.
So shall we conclude?
yes, Anjali, we were waiting for you only.
Okay, okay. Thank you very much, sir,
Thank you
for
very much.
such a nice and interactive session.
Thank you very much.
And
Thank you,
thank you
Anjali.
all the participants for attending these sessions.
Thank you. Thank you.
Thank you very much.
thank you, Anjali. Please send the
Thank you.
CP.
Thank you.
Sure,
Please
Send
sure.
send the CP certificate ASAP.
The confirmation and PPTs will be shared by Monday.
ठीक है. Thank you so much. Thank
thank
you.